My name is Sue Hobbs. I'm an assistant professor in child development. So for child victims, participating in the legal system can be traumatizing. And for children, two of the most traumatizing parts of this experience are seeing the defendant in the courtroom and cross-examination. In the United States and many other countries in the world, defendants are allowed to represent themselves. In the U.S., the Sixth Amendment of the Constitution allows defendants the right to face their own accusers in the courtroom. Thus, in cases like this, defendants who are representing themselves are allowed to cross-examine their own victims. And this is even in cases when the victims are children or the crime is violent or sexual in nature. Therefore, child victims in these cases must not only endure facing the defendant in the courtroom, they must also endure cross-examination by that defendant. It is up to the children's attorneys to demonstrate that having a defendant cross-examine children would cause extreme harm. In addition to our findings on children's feelings about appearing in court, seeing the defendant in the courtroom and cross-examination, our research also demonstrates that distress can impact the reliability of children's reports, and also that children are less accurate when they are questioned by a person who is not supportive. A colleague and I have written a research-based recommendation to limit the way that children are cross-examined in cases of self-representing defendants, so that intermediaries pose the questions to the children rather than the defendants posing the questions themselves. In this way, both the defendant's rights and the children's rights are protected. Attorneys, prosecutors, child advocates, judges, and juries would all benefit from reading this work. And of course, child victims would benefit from people reading the work as well. We are currently working to disseminate our work to senators who have expressed interest in sponsoring a bill that would limit defendants from cross-examining their own victims. Additionally, the Supreme Court of the United States has expressed interest in this topic about whether or not defendants should be allowed to cross-examine their own victims, their own child victims. Thus, we hope that our work would be of interest to the Supreme Court if they do have to make decisions about self-representing defendants cross-examining their own child victims. The research-based recommendation that I was just speaking about will be published soon in the International Journal of Child Maltreatment.